Welcome to meeting number 64 of the Standing Committee on Foreign Affairs and International Development. Today's meeting is taking place in a hybrid format pursuant to the House Order June 23, 2022. Members are attending in person in the room, and as far as I understand, we have no one online. So I'd like to make a few comments for the benefit of the members beforehand. First of all, since no one's online and we don't have to spend any time on that, would like to inform all the members that today is Ms. McPherson's birthday. Happy birthday, Ms. McPherson. So on a less happy note, if I may, I'd like to ask all the members that they wait until I recognize them by name before they speak. Unless it's Heather, of course. She has all rights today. So a reminder that all comments should be made through the chair. Now, pursuant to the order of reference of Monday, February 13th, 2023, the committee commences consideration of Bill S-8, an act to amend the Immigration and Refugee Protection Act to make consequential amendments to other acts and to amend the Immigration and Refugee Protection Regulations. Concerning the drafting of any amendments that may be proposed by the members, I would like to highlight and remind everyone that members should contact Alexandra Shora, the Legislative Counsel, as soon as possible should they intend to introduce any amendments. Now, it's my great honor to welcome the sponsor of this bill to our committee. It's a great honor to have the Honorable Minister Marco Mendicino here with us. So we look very much forward to his opening comments. However, before doing so, I just wanted to thank all the officials who are accompanying him today. From Canada Border Services Agency, we have Ms. Kelly Acton, the Vice President, Strategic Policy Branch. We have Mr. Brett Bush, the Executive Director of the Immigration and Asylum Policy Innovation Branch. From the Department of Citizenship and Immigration itself, we have Simon Fredette, the Director of Migration Control and Horizontal Policy Division, and Mr. David Chan, Acting Director, Asylum Policy, Performance and Governance Division. From the Department of Foreign Affairs, Trade and Development itself, we have Mr. Stephen Burridge, the Director of Sanctions Policy and Operations Coordination. And finally, from the Department of Public Safety and Emergency Preparedness, we have Mr. Sebastian Oberton Giguère, the Assistant Deputy Minister, National and Cyber Security Branch. So all of that being out of the way, thank you for appearing here today, Minister, for your opening remarks. You have 5 minutes.
Thank you very much, Mr. Chair, as well for the introductions of the officials who are joining me. Bonjour, Monsieur le Président.
Good morning, Mr. Chair, members of the committee. Thank you for inviting me to speak to the objectives of Bill S-8. Canada will never be a refuge for bad actors. The amendments proposed in C-8 will address the current shortcomings within our sanctions framework for things to be perfectly clear by aligning the Immigration and Refugee Protection Act and the Special Economic Measures Act.
Are clear and will ensure that all foreign nationals subject to any sanctions under the Special Economic Measures Act, or what we refer to as CEMA, will also be inadmissible to Canada pursuant to the Immigration and Refugee Protection Act. Bill S-8 will modernize Canada's sanctions inadmissibility framework. From a border integrity perspective, the amendments proposed by Bill S-8 are the best way to ensure that a sanctioned person would be deemed inadmissible to Canada. Since February 24th, 2022, when Russia launched its brutal war against Ukraine, Through its latest illegal incursion, the Government of Canada responded with numerous packages of new sanctions targeting many Russian and Belarusian individuals and entities. As of March 1st, over 1,500 individuals have been sanctioned under the CIMA in relation to this conflict. This is in addition to the more than 1,000 other foreign nationals sanctioned under CIMA who are tied to other countries and or regimes such as Myanmar, Syria, and most recently Iran, following the so-called morality police's brutal human rights violations, just to name a few. While some of these individuals are currently inadmissible to Canada, the majority are not. Si un ressortissant étranger sanctionné se présente,
should a sanctioned foreign national arrive at a Canadian border, Bill S-8 will ensure that a CBSA officer can immediately make a finding of inadmissibility and can remove the person from Canada.
Also mean that the roughly 2,500 individuals currently sanctioned under CIMA for grounds not linked to IRPA would be inadmissible to Canada. As the IRPA is currently written, its inadmissibility provisions do not align with the basis for imposing the majority of CIMA sanctions issued against Russia, and that is precisely what S8 seeks to remedy. Ces amendements s'appliqueront au-delà de la situation.
These amendments will apply beyond the situation currently underway in Russia and Iran. They will be in a position to act against other organizations such as Al-Qaeda and ISIL.
Will also strengthen Canada's ability to identify and stop sanctioned foreign nationals before they travel to Canada. Simply put, there are currently no parallel existing grounds of inadmissibility, which is why the legislative amendments as proposed in Bill S-8 are so crucial. They will ensure that the Government of Canada's sanctions framework remains cohesive, enforceable, and responsive. The bill will provide Canada with much-needed authorities to hold bad actors to account and to contribute to concerted action with our international allies. It will provide a clear and strong message that the Government of Canada's comprehensive sanctions framework has meaningful consequences, not only from an economic perspective, but from an immigration and access to Canada perspective as well. Merci de votre temps.
Thank you for your time, Mr. Chair. I'd be happy to answer any further questions you may have.
Thank you very much, Minister. We will now open the floor to questions from the members. We first have MP Genis. MP Genis, for this round, everyone has been provided 6 minutes. The floor is yours.
Thank you, Chair. Thank you, Minister. You're going to be using, I assume, information from CSIS when you make sanctions inadmissibility determinations. Does CSIS intelligence contribute to decisions about who gets sanctioned under CIMA or is otherwise deemed inadmissible?
I would say they are one of a number of agencies that contribute to the analysis, which is undertaken by Global Affairs prior to listing under CIMA.
Thank you for that answer. How often are you briefed directly by CSIS?
I'm routinely, certainly at least once a week and often more frequently than that.
Okay. So you receive direct briefings from CSIS once a week or more often?
That's correct.
Okay. My understanding as well is that CSIS often communicates through written products, through intelligence assessments. Do you read intelligence assessments as well, separately from those briefings?
Yes, and it's not always supported by written assessments, but yes, I do see written assessments, intelligence assessments.
Okay. Do you read all intelligence assessments that would come into your department?
I certainly get summaries of intelligence assessments, and then that is supplemented by verbal and other briefings from CSIS officials.
Okay. So who receives the full intelligence assessments, and who's responsible for summarizing or you deciding what information to bring to your attention or not bring to your attention?
My deputy minister and chief of staff are the two most principal advisors to me who help to prioritize exactly what it is that is put before me in terms of intelligence.
Okay. Would your chief of staff and your deputy minister read all intelligence assessments then?
I'm fairly confident that yes, between the two of them, as well as the staff that are in their offices, are able to get access to those reports and then help to prioritize what gets put before me.
Yeah, just to put a fine point on to make sure I'm understanding right, because I'm sure they're able to get access to them. But if an intelligence assessment is sent to your department, can you say that yes, the deputy minister and the chief of staff reads them, or one of them reads them, or would they be reading a summary that somebody else prepared for them?
I think often it's both. So in other words, they will get both the complete report as well as a summary. And sometimes they, from the reading of the report, will prepare summaries which then directly come to me.
Okay. But your expectation is that both of them would receive and read the intelligence reports?
And that they are delivered, yes, that's correct.
Okay. Have you given CSIS direction in terms of what issues they should or should not brief you on? Anytime X, Y, or Z comes up, I want to know about it directly, or have you given that kind of direction to CSIS?
Yes.
Okay. Will those making recommendations about sanctions or inadmissibility, will they always receive those intelligence assessments? Like, is that one of the things that, because as minister, you will make those determinations around sanctions. Will you directly review intelligence assessments related to those sanctions?
Can you just clarify your question, Mr. Genis? What information are you asking about to support which decision?
Decisions around sanctions, because this is related to the bill. If somebody brings, if you're making a determination about a sanction, would you ask CSIS to provide you with the intelligence assessment directly, or would you rely on summaries in that case?
I may rely on summaries, and if I've got additional questions about the source information which went into the summary, including the original intelligence report, I will certainly ask questions, yes.
Okay, thank you. One primary area in which we've seen motivation for sanctions is sanctions against individuals or entities that are involved in foreign interference activities here in Canada. So in relation to that, I want to ask you if in 2021 there was information in an intelligence assessment about Canadian MPs being targeted by the PRC. Was that information in any intelligence assessments in 2021?
Well, as you know, I very much appreciate your question. I have to be guided by the law under the Security of Information Act in terms of what I can and cannot disclose. There are strict constraints on that, but we have created forums in which we can declassify that information or allow parliamentarians and or officials to have access to that information so that it can be discussed with Canadians. And I would cite public reports that have come from NSICOP and CIRA in which we are able to navigate those types of questions.
Okay. If an intelligence assessment contained information, you've said it would your expectation would be that it would be read by the chief of staff and the deputy minister.
Point of order, Mr. Chair. We're here on S8 today. I'm just wanting to make sure that we're getting evidence that relates to S8 in terms of this committee, so we can advance our understanding and even propose amendments around the legislation. I'm just trying to listen for how this actually pertains to S8 specifically, and I would ask the members through you to focus their questions on S8.
Thank you, Mr. Sperry. I'd like to remind every member that we should try to focus our questions on the issue at hand, which is S8. Mr. Genis, we did stop the clock. You still have a minute and 12 seconds remaining.
Thank you, Chair. If information in relation to individuals involved in foreign interference, potentially who should be sanctioned as a result of that foreign interference, if that had been an intelligence assessment in 2021, your expectation is that the chief of staff as well as the deputy minister would have seen it and that you would have been provided with a summary of that information. Is that correct?
Well, let me just clarify, because I think you're referring to the recent events involving your colleague, Mr. Chong. You heard the Prime Minister indicate that there is a new directive that has been issued to CSIS to ensure that if there are allegations or reports around foreign interference that involve parliamentarians, that come directly to the attention of the Prime Minister as well as myself, and I assure you and all of the colleagues here that we will adhere to that directive.
But prior directive, you still think the Deputy Minister and the Chief of Staff would have seen that information, correct?
Well, I think, look, it's a very important question that you're asking. I think it's also important to remind members of this committee that CSIS and other intelligence agencies make determinations and judgment calls on what intelligence is actionable.
It's a question that deserves an answer, though. Would the Chief of Staff or the Deputy have seen it? Okay, thank you, Chair.
Thank you, Mr. Genis. We next go to MP Zuberi. You have 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair, and thank you, Minister, for being here today.
And team for being here. I'll pick up on the line that was really touched upon by my colleague from colleague opposite. And first off, before doing so, I'd like to just acknowledge that I respect immensely the work you're doing to protect Canada. You and other ministers are doing to protect Canada from foreign interference and to protect our democracy. That being said, I'd like to lean into the questions around foreign interference and ask how will S8, in particular, help to protect our country from foreign interference?
Through you, Mr. Chair, to my colleague, Mr. Zuberi, first, thank you for the question. Thank you for your advocacy as well on matters especially pertaining to human rights and for standing against authoritarian dictatorships who are oppressive. I want to just take a moment to express my gratitude to you. I would also say that in addition to the bill that is before you that will help to align the work that our colleagues at Global Affairs do in listing individuals under CIMA to the Immigration and Refugee Protection Act, that there are existing authorities that do deal with, for example, espionage. And by virtue of those authorities under the Immigration and Refugee Protection Act, an individual can be deemed inadmissible if there are grounds to believe that they have committed an act in relationship to espionage. But what this bill will do is it will further close any existing loopholes if, for example, there are specific individuals who have been listed under the Special Economic Measures Act, or CIMA, and align that in express language under IRPA so that they are deemed inadmissible, but only after an analysis has been undertaken by Global Affairs.
So this will help to further protect Canada from foreign interference, this important legislation.
Absolutely.
We work in partnership, Canada works in partnership with many countries, Five Eyes, G7, other countries. And I'd like you to just elaborate a bit upon how S8 contributes to what other countries are doing in this domain. Can you speak about how other countries are addressing the issue that S8 puts forth and how that fits in within the schema?
Well, I will defer to officials who have undertaken an analysis of exactly what kind of legislative or statutory schemes are in place among our democratic allies, but I believe that S8 will generally align with the approaches that have been taken by like-minded countries. The point is to make sure that there is not a disconnect, that if an individual has been named under CIMA because they are facilitating the transgression of human rights or are in some way supporting financially or otherwise the acts of an authoritarian regime, like, for example, in Russia, as it continues its illegal incursion and war in Ukraine, that individual then becomes inadmissible to Canada by operation of statute, and that statute is IRPA.
So this legislation touches individuals. It also touches entities in terms of exclusion. Not exclusion, in terms of the sanctions regime, touches not only individuals but also entities. Is there any impact on shareholders of entities that might be sanctioned when it comes to S8? support legislation, the broader legislation?
Again, through you, Mr. Chair, to Mr. Zuberi, I will defer to officials exactly on what their impact analysis is with regards to potential impacts on shareholders. But I do want to clarify, because you used the word specifically, that entity is not in the bill, and that is for good reason. We believe that we have crafted language which is precise and clear, and allows us to focus on individuals who have been named under CIMA, and that is the best way to align the objectives of CIMA with IRPA.
And lastly, in the next minute, we, Canada, have been a steadfast ally of Ukraine, as many other countries have been. And you touched upon how this legislation, in terms of the sanctions regime, have actually helped in our efforts when it comes to Ukraine. Do you want to elaborate a bit more upon that in the time that remains, in the 45 seconds that remains, about how S8 will further our solidarity with Ukraine and check Russia's aggression?
It will ensure that the individuals that have been listed under CIMA, who are in some way supporting Russia's illegal war in Ukraine, are deemed inadmissible. And that is just the latest measure that we can take to support Ukraine. I would point out that we have been with the people of Ukraine since February of 2022, March of 2022, through a variety of initiatives, militarily, diplomatically, by creating immigration pathways to help those who've been displaced, and equally through the work that we are doing in my portfolio by, among other things, sending the RCMP to ensure that those who are committing war crimes and other transgressions against human rights are held to account. And we will continue to be there for the people of Ukraine and Ukraine to ensure its sovereignty.
Merci.
We next go to MP Bergeron. You have 6 minutes, sir.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you so much, Minister, for being here with us. Thank you to all of your colleagues, the officials. Can you start by asking us why you started with delivering this bill before the Senate to start? Really, it was for technical reasons. It had to do with the process that the government used. I mean, it's an option. There are many things that we needed to do in the House of Commons, so sometimes we go through the Senate to advance other priorities like this one, to make sure that we can achieve the end that we all want, which is to close loopholes, to align the work under CIMA with IRPA. In sections 5 and 6, there's a definition of inadmissibility as including sanctions. What does that mean exactly? What does sanctions actually mean? As for a technical analysis, I would defer to my colleagues, the officials here. But in a practical sense, the analysis under CIMA examines matters that have to do with corruption, other activities which are illegal, pursuant to international conventions. And if there are records of or evidence that satisfies those tests, then that is regulated under CIMA. The purpose of this bill, S8, is to align the work under CIMA with what's done within IRPA, so that person is inadmissible. I know you couldn't have been aware of this, but the committee intends to do a study on the Canadian sanctions regime, and certainly we have the feeling, the group that will be looking at the sanctions regime, it seems as though you're putting the cart before the horse in a way, because the legislative process forces us to go with the bill first, then we might as well go ahead. You might have heard of some concerns raised by the refugee groups that a person who is persecuted in their home country could be denied in terms of an asylum claim, even if they haven't done anything reprehensible themselves because of what might have happened in their country of origin. What would you do with that? Answer, well, that's a good question. We'll certainly be working with organizations that represent refugees and asylum seekers. Our government has a strong record on our priorities. We have one of the, perhaps the strongest asylum claim regime in the world. But to answer your question, we will have trust in our officials at Global Affairs for them to do analyses that are based on fact. Afterwards, if they meet the test, when this bill enters into force, that will mean that a person may or may not be admissible. If there are individuals where you can't satisfy that test, then the bill will not be triggered. What's in the bill will not be triggered. To be clear, Minister, are you saying that regardless of what the bill actually says, an asylum seeker coming from a sanctioned country could still have his or her claim looked at? I would say that each case is based on its own merits. The register under CIMA, and by extension what's happening in this bill, well, prior to all that, there's an assessment of all the facts, and that would look at all of the circumstances affecting an individual in the context of an analysis done by the department. The Canadian Bar Association proposes the following measure, that modifications or amendments be made to the Immigration and Refugee Protection Act, establishing a distinct grounds for admissibility for sanctions with respect to an entity, a person, or that would do away with the reference to country, which it finds is too broad, given the concern that I've just mentioned, concern of these refugee communities. What do you think of this Canadian Bar Association notice? Of course, the refugees' rights need to be protected. You have to protect people who are really in a vulnerable category. The purpose of this bill is precise. It is aligned with CIMA, and I hope that you have trust in the officials that are doing the analyses prior to someone being registered under CIMA. I think, in brief, there are checks and balances. There are parameters in line to look at all of the circumstances, even if there are current concerns with respect to the rights of refugees within the analysis prior to concluding the CIMA process. That is one way for us to protect the rights of individuals and to make sure that this bill aligns with the exercise under CIMA.
We now go to Madam McPherson. You have 6 minutes.
Thank you, Mr. Chair. Thank you all for being here today and answering our questions on S8. And I'm very grateful for you taking on sanctions. I think it's very important for us to strengthen our sanction regime. As Mr. Bergeron mentioned, we are going to be undertaking a study. That was a study that I had brought forward for us to look at. One of my big concerns with our sanction regime, of course, is the enforcement of the sanction regime, because it's very easy to put people's name on a list. It's not always very easy to make sure that those sanctions are being enforced. With regards to S8, though, I do have a few questions. So Minister, you've heard me be a little bit critical before when the sector, when experts are not consulted. We might get to C41 later on today. I have something I'd like to ask for my birthday, Mr. Minister.
to give you a present. We'll see.
So with regards to S8, though, you know, the legal experts, the refugee sector have said that there do need to be amendments to this bill. They have called for that. I think Mr. Bergeron referred to you know, the use of the word sanctions. So we have heard from the Bella Mesa Law Group, from the Refugee Center, that they've both raised concerns about the lack of clarity with regards to language on sanctions in this bill. And of course, we have the study that we will be looking at this. Why is it so vague? How do we make sure that that's better? Would you be willing to accept amendments on that with regards to that?
I'll say a few words off the top, and then I would encourage you to hear what Mr. Bush has to say, because I want to be responsive. But as I was saying to your colleague, Mr. Bergeron, that prior to the operation of this statute, there would be a rigorous examination of all of the facts under CIMA that could look at all of the facts and circumstances before a conclusion is rendered on as whether or not that individual is listed. I appreciate that if I understand your question correctly, Ms. McPherson, it's that we want to make sure that this statute is not vague or overbroad. I think those are laudable objectives. I would encourage you to...
And concerns that the Canadian Bar Association has brought forward with regards to this legislation as well.
And we want to make sure that they are sufficiently focused and constrained, but perhaps Mr. Bush might be able to say something specifically.
So, okay. Thank you. So we in fact did meet with the Canadian Bar Association about these concerns and had several discussions, but the short answer would be this. The sanctions regime is managed by our colleagues at Global Affairs. We did not agree with the suggestion that we should be importing language from the sanctions into IRPA, because it is not the place to assess the sanction. The place to assess the sanction is with our colleagues at Global Affairs. We also don't agree with the Canadian Bar Association in the context of the various mechanisms for seeking redress to the sanction. There, in fact, and my colleague at Global Affairs could speak about this, there are measures for seeking redress to the sanction. The measures in IRPA that the Minister has been speaking about are simply to ensure that the people who have been sanctioned by the government are now inadmissible, as you, in fact, mentioned a few moments ago. The last point that I would mention, and I just lost my train of thought, and I'm sorry.
Two out of three is not bad. So I want to make this clear. So.
Or official from GAC as well. Did you want to add anything to that?
Sure, maybe just on the point around redress for sanctions. So there is the ability for a listed individual or entity to apply to the Minister of Foreign Affairs to be delisted from sanctions. That decision does rest with the Minister of Foreign Affairs on whether or not an individual is delisted from our sanctions regime. Further to that, they also do have recourse to have the listing itself or the decision on the delisting application brought before a court and judicially reviewed.
So I guess one of my concerns, of course, is always that there will be consequences, unintended consequences that folks that shouldn't be on these, that shouldn't be suffering punitive actions will suffer. I think that is, again, what we saw in C-41 when we weaponized international development instead of preventing terrorism from being funded. So my concern, of course, is that what we're looking at right now is if somebody wants to appeal, doesn't agree with this decision, shouldn't be on this list, shouldn't be added, they have to come to you, then they go to Minister Joly, they get all of these things clarified, and is that mechanism actually going to work? Because you will know that the business of government is not a quick situation. No intended insult directly to you.
Well, I appreciate that clarification, Ms. McPherson. There are available avenues of relief to the federal court, which provides judicial oversight in the exercise of the functions under CIMA as well as under IRPA, which again will now function as a two-turnkey system to ensure an admissibility. But I just come back to the central premise of your question, which is what are we doing to safeguard against the potential of inadvertent overreach here, and especially with regards to vulnerable individuals who may wish to claim status as either an asylum seeker or as a refugee. And I am confident that this new bill will not in any way diminish from the existing pathways to protect those rights where they exist under IRPA and the law.
So the refugee sector is not as confident as you are, Minister. So will you be open to amendments to this legislation?
As you've heard me say many times before, Ms. McPherson, I'm always prepared to work with you and this committee and other parliamentarians if we think that there is a realistic and practical way in which to either provide clarification on the existing language or to strengthen it. I will keep an open mind about that.
Thank you.
We now go to the second round. For the second round, each member is provided 4 minutes. Mr. Genis, you're up next.
Thank you, Chair. Minister, you had strong words for CSIS on the weekend. I want to ask, do you have confidence in CSIS, and do you blame CSIS for the fact that Mr. Chong was not informed about a threat against his family 2 years ago?
Point of order, Mr. Chair, on relevance, given our stated agenda for this meeting being the consideration of Bill S8, and I would just like you to consider that. Thank you.
Chair, can I respond to the point of order?
Yes.
Yeah,
Chair.
Chair, I think the minister's confidence or lack thereof in CSIS is critically important given that part of S8 is responding to assessments that are made by our security agencies.
Thank you, Mr. Genis. I'd just like to urge all members to keep it within the ambit of the bill before us. Mr. Genis, please proceed.
Thank you, Chair. Minister, you heard the question. Would you like to answer it or not?
No, I'm quite content to answer it, and I appreciate again why you're asking these questions, despite the fact that we're here principally to talk about Bill S8. But of course, I've got confidence in CSIS. I mean, these are individuals who work to protect our national security every day, and I also would point out that your question used language like blaming. The only people that I think that we need to be united in holding accountable are the hostile actors who are attempting to undermine our democratic institutions. Mr. Genis.
Thanks, Mr. I can just jump in there. I think there's probably agreement that something went wrong 2 years ago, though, and if you think blame is too strong a word, fair enough. But who carries this error? Who do you think carries this error in that someone was not informed about a threat against their family? Was the error made by CSIS? Was the error made by the minister? Was the error made by the chief of staff? Who made the error?
I think we have to be constantly vigilant to make sure that our internal governance, including directives around what gets briefed directly in person to ministers who are responsible, including and up to the Prime Minister, reflect the state of the landscape when it comes to foreign interference. And Mr. Genis, you put a lot of time into studying this subject matter. I think you would acknowledge that threat landscape has evolved significantly in the last few years alone, and it's probably evolving just about every day. So making sure that our directives align to those realities is important to ensure accountability.
Thank you, Minister. I'm going to move on, although I don't know that I fully got the response there. At the end of my last round, I had asked you specifically if your chief of staff or deputy would have seen the 2021 intelligence report on foreign interference. Could you clarify? Did the minister or the chief of staff see that report?
Well, again, only because you put the question directly and personally to me. I was not in this portfolio in July of 2021 when the report was alleged to have been, it has been reported in public. But again, we are making sure that our directives do reflect the landscape as it exists today, so that if there are reports that touch on parliamentarians, MPs, and the like involving foreign interference, that they will now come directly to me and the Prime Minister.
Okay, so I guess the answer is you don't know if the deputy or the chief of staff read the report. But you said it's general practice for the deputy or the chief of staff to read these reports. But in the particular case, you're saying you weren't the minister, so you don't know. Is that
point of order? Just back to my first point of order. In terms of the relevance to S8, I'm trying to understand how this will help our committee study with respect to S8. I don't yet see that I'm not sure, Mr. Chair, if the questions to be more focused around S8 or like, are we just talking about what's in the news today?
Remind all the members to remain focused on S8 and to make their questions relevant to the bill at hand. Mr. Jennings.
Thank you, Chair. Thank you. In my final minute, I want to pick up on something you said, Minister. So it's the matter we're dealing with at hand, which is on the directive that you have issued to bring foreign interference targeting elected officials to your attention. Does that apply to provincial and municipal elected officials as well, or just parliamentarians?
I would certainly start by prioritizing the members of Parliament with whom we work with in the House of Commons, but I also want to assure you, Mr. Ginnis, that we're looking at other levels of government. In fact, CSIS has provided
just specifically in
briefings.
terms of the directive, because I'm almost out of time. Does the directive cover provincial and municipal elected officials?
We will ensure that we are briefed directly on parliamentarians and will make additional refinements as may be needed.
Okay.
But I think this is important. CSIS has briefed other levels of government at their request, most recently a number of
But it's a question of
premiers.
what information is coming to you and the Prime Minister, because it seems to me that if an everyday citizen is facing the threat of foreign interference, that should be treated with an extreme level of seriousness.
Point of order.
And,
I agree.
I think that's my time.
Again,
Thanks.
The S8 relates to amendments around sanctions. I'm not sure how this will help us to understand those amendments around, or not amendments, but legislation that goes on top of
Briefly,
sanctions.
Minister, because we're out of time.
Mr. Chair, as you can see, I'm trying to be as responsive as I possibly can. I think we are moving a bit afield of the four corners of the bill that we are here to debate, but I want to be transparent with Mr. Ginnis and all of you. Look, we take the issue very seriously. We're being upfront. We're putting in place with the tools that are necessary to ensure the safety and security of all parliamentarians, and this is going to be the ongoing work that I hope we can do across the aisle.
Thank you, Minister. Next go to Dr. Fry. Dr. Fry, you have 4 minutes.
Thank you very much, Chair, and thank you, Minister, for coming and answering all the questions that you asked and trying to be transparent with regard to those questions. I think that's very important. I just wanted to go back to what the Canadian Bar Association said. They felt that the concept, which included country, made it too broad. How are you going to deal with the idea that everyone coming, take Russia, for instance. I mean, we're clear about who we're sanctioning in Russia. Question is the Duma, the whole Duma sanctioned in Russia? And what about individuals and the country? Just because you're a Russian living in Russia, does that mean you're sanctioned? I think that's something that people really want to know because it's broad. I think that was a question from the Bar Association. The other question I want to ask is refugee claimants who are from a sanctioned regime have that ability to come and seek individual admissibility as a refugee. Who is going to look after that? How is that going to be investigated? You said on a case-by-case basis, but where is the buck going to stop in terms of that investigation?
Through the chair to you, Ms. Fry, I would say I appreciate both questions. I think they're related. So in the first instance, the operation of the bill that is before you, once it is in force, will only be triggered after an analysis has been undertaken by Global Affairs with regards to the listing of an individual under the Special Economic Measures Act, or CEMA. That analysis, as I understand it, within the expertise in the domain of Global Affairs, focuses on gross human rights violations, focuses on corruption. And those judgment calls are made on the basis of the facts that are before them. So they will look at whether or not the individual has been in some way affiliated with a hostile actor or an authoritarian regime that is perpetrating those bad acts, or those gross human rights violations, that corruption. They will be entitled to look at the entirety of the record before them. If they are satisfied that the threshold is met under that statute, then that will automatically trigger the inadmissibility under the new provision which we are proposing under Section 8 under the Immigration Refugee Protection Act. And the point is to ensure that Canada is not a safe haven for any individual who may be trying to prop up an authoritarian regime.
I wanted to ask about the question of entity. I think my colleague, Mr. Saberi, asked that question with regard to entity. If someone inadvertently, is a member or stakeholder, a stockholder or whatever in an entity, how do you define entity? Because entity is not fully defined in this bill. How do we define that clearly?
I believe that that's an important question, as I mentioned to our colleague, Mr. Saberi, that the word is not used in Bill S8. That was a conscious decision so that we don't in any way conflate or confuse the analysis, which is focused principally on the individual first and foremost, that is before global affairs, for analysis under CIMA.
I know, but the question is, unless you define entity clearly in the bill, how are people going to understand what you mean when somebody owns shares in a company that is carrying on the acts and didn't know about it? How is that definition going to be used? I think that's the clarity that people are seeking a little bit.
Yeah.
So people don't get inadvertently caught.
And again, Mr. Chair, through you to Ms. Fry, perhaps Mr. Burridge from Global Affairs might be able to shed some additional light, because the analysis really does fall within the remit of GAC, and I would invite Mr. Burridge to add a few words about this.
Thank you, Mr. Chair. Maybe what I would say is that individuals and entities are listed very specifically under CIMA. So the sanctions themselves apply to the specific individuals or entities that are listed. In this way, there's a dealings prohibition that is put on Canadians and preventing them from being able to deal or to transact with those specific individuals or entities. So that said, when we're talking about inadmissibility, the inadmissibility would apply to those individuals and entities that are listed under CIMA. Shareholders, for instance, may or may not be listed individually, so the inadmissibility only applies to those that are actually listed under CIMA.
Thank you. That clarifies that greatly. How much time do I have, Chair?
That's it? Yes.
Thank you.
So we next go to Mr. Bergeron. You have 2 minutes, Mr. Bergeron.
Merci,
Thank you, Mr. Chair. In the context of the second reading debate of S8, you received the report from our committee about an effective and efficient framework for our sanctions regime, honoring the memory of Sergei Magnitsky and going further than that. And you were referring to the Immigration Refugee Protection Act being amended to designate all individuals sanctioned under the Special Economic Measures Act as inadmissible to Canada. You said that it was the most effective and most efficient way of determining who was inadmissible to Canada in the travel process so that that person would not be able to access a visa to come to the country. You were a Minister of Immigration. Why did you wait more than 5 years before going ahead with this bill? Why wait for the war in Ukraine before finally proceeding to the implementation of the recommendation made by this very committee and reformulated in 2017?
D'abord, en tant que
First off, as former Minister of Immigration, we accomplished a great deal. During the pandemic, we reorganized the immigration system to welcome a record number of immigrants. In my view, this has been good for the creation of jobs, it's been good for the economy, and it's also been good to protect Canada's record when it comes to refugees and vulnerable persons, as you already asked me in the previous question. Now, we're dealing with a bill that will strengthen the authorities that already exist today to reassure everyone that Canada will never be a safe haven for anyone who supports in any way authoritarian regimes.
Two minutes is very fast. I guess going back to one of the concerns that I was raising earlier about the impact on those that may inadvertently be on the list incorrectly or may disagree with that assessment. You've outlined that there are processes to do that with, that there are processes for people to get redress or to get an appeal, but yet those things cost an awful lot of money and they take an awful lot of time. In fact, my team, who are remarkable, have explained that it can cost thousands of dollars. We know refugees don't have thousands of dollars. How will you mitigate this risk?
Look, I think it's an entirely important question to make sure that we respond to. I will say that there have been some modifications, and Ms. McPherson, if you will allow me to clarify one of the answers that I provided earlier, and my officials will expand on that there are some references to the use of the word entity. This is a key change to the project of law, which is before the committee, and it ensures that sanctions against a non-state actor like an ISIS or a Taliban or Al-Qaeda are inadmissible. So I just wanted to make sure that I put that clarification on the record.
But so the answer to that this could cost thousands of dollars that refugees won't have, so they won't actually have access to justice, to access to the systems that you've put in place to protect them. Your answer is?
Well, our answer is that, in fact, I know my colleague, the Minister of Justice, has put in place additional legal aid supports to ensure that those who are seeking asylum or seeking to make a refugee claim are able to get access to legal aid services to navigate the system. I know as well that working closely with organizations that do advocate for refugees like Carl, with whom we have close relations, that we are putting clear information on our websites to make sure that they can navigate those processes.
So the access is through legal aid, and it has been, just to clarify, it has been increased so that it can accommodate some of the needs?
We are endeavoring to make sure that there are legal aid services that are in place.
So it hasn't been increased to accommodate the need?
IRCC has put in place some additional, is working hard, I beg your pardon, to ensure that we address those challenges.
Thank you. We now go to Mr. Jennings. You have 4 minutes.
Thank you, Chair. I do want to underline that the use of intelligence assessments from CSIS is very important for our discussion of sanctions. It's one of the key, I assume, actually, as the Minister said at the beginning, it's one of the key sort of evidentiary
Could I just
inputs.
clarify the rounds and how this is happening? I thought the Minister was here for 1 hour.
Yes, we still have 2 more questions remaining.
2 rounds or 2
2 4-minute slots.
Okay,
Yes,
thank you.
Shall I resume?
Please,
Okay.
Mr.
Thank you, Chair. So, in that vein, for information used by the Immigration Department that will be involved in the determinations about inadmissibility, I assume that when intelligence assessments are done by CSIS, they go to some point person in the Immigration Department. Is that correct?
If there are inadmissibility concerns, then those intelligence reports will be shared with the appropriate departments, yes.
Okay. And then it's up to the point person in immigration to share with those within the department that need to see it. When you were immigration minister, who in your office would have received this kinds of intelligence information? Would it have been you directly, your chief of staff, your deputy minister, somebody else?
As a matter of general procedure, Mr. Jennings, it would depend very much on the significance of the case. Obviously, there are many, many cases which are dealt with and addressed by our delegated authorities, so not all of them would come up directly to my attention. So it would depend very much on the individual particulars of each case.
Okay. But someone must have been responsible for receiving the intelligence assessments and deciding who needed to see it and who didn't see it. So at what level would that person have been?
It'll depend on, again, the particulars of the case, but this is where we get back to questions around internal governance. Ultimately, a minister will depend on their chief of staff and their deputy minister to help prioritize that information flow.
Okay. So in your current role at Public Safety, aside from your chief of staff, which other positions held by political exempt staff in your office receive access to intelligence assessments?
Point of order, I'm trying to again understand how this relates to S8 and the new legislation on...
You'll see.
What is the difference between these words and not defining?
I don't see any relevance whatsoever, so if I could just remind you once again to remain within the ambit of Bill S8.
Further to that point of order, Mr. Chair, it's not only relevant, it's also a parliamentary tradition in that a minister has responsibility when they are the minister, and it is not normal by any stretch of the imagination under parliamentary tradition to be asking ministers about their previous job, because there is a Minister of Immigration now who has that responsibility. Thank you.
Just Chair, on the same point, I've actually moved past that point for better or worse. So,
The point is made.
sure.
Let's just try to keep this relevant, Mr. Jennison.
Thank you, Chair. I did ask a question, so out of respect for the minister, just is he interested in answering the question, given the
Point of
questions on the
order,
record?
Mr. Chair. I
Just
thought
trying
you
to-
already spoke about this question and this line of questioning.
Yeah.
And
I'm
we're
trying to
seeming
extend the
get
courtesy to the
ex-
minister, if you don't see.
I believe
not.
we're still getting the exact same question being reformatted when you already expressed yourself as chair on the matter.
Is he the chair?
Mr. Jennison.
Thank you, Chair. I appreciate that there may be some disagreements about the issue of relevance. The point I made at the beginning was that use of intelligence assessments is critical for sanctions, and the minister made that point himself. So I'm curious about who sees intelligence assessments, because those are the inputs for decisions about sanctions.
On that point of order, Mr. Chair, point of order.
Can we
the reality is, as the minister has explained, the actual functioning of the sanctions, both on who is sanctioned and how they are delisted from sanctions, is not the responsibility of this minister. It's the responsibility of the Minister of Foreign Affairs. This activity is about stopping people who are sanctioned from getting into Canada, which has been a call from all opposition parties, as well as the government parties, to ensure that our sanctions regime is robust enough to make sure that people are inadmissible.
Mr. Jennings, please do bear in mind that we're trying to remain focused on Bill S8. You have a minute and 54 seconds remaining.
Minister, out of courtesy for you, having asked the question, I wonder if you're interested in answering it or not. If you'd like to address it.
Point of order. I don't know how many times you, as chair, need to repeat yourself for us to actually get it in our heads about this line of questioning.
Can I not offer the courtesy to the minister to respond to
You know,
what's
it's
already on the public
unbelievable.
record?
Mr.
Unbelievable.
Jennings, please, you've been warned several times.
Mr. Chair, I think the question I'm asking is relevant. It's about intelligence assessments that can then be used for sanctions.
This is the fourth
so
time.
My question.
Point of order.
Yeah.
Sorry.
Yeah. Look, Minister, do you have any comment you want to make one way or the other on the foregoing discussion?
Mr. Jennings, I've been, I think, pretty forthright in answering the question that you posed now a few times.
Okay, I don't agree, but the public will judge, I suppose. Is there anybody in your office that you can say 100% of the time reads the intelligence assessments that come through?
I believe you asked that question on a couple of occasions earlier in this hour, and you have my answers on that.
Could you repeat it? Is there anyone in your office who you can say with certainty reads 100% of the intelligence assessments that come through?
Yes, I explained that the combination of the officials that work within the Deputy Minister's office and my ministerial office will take a look at those reports and then prioritize what gets sent to me, either directly through the report or through a summary or through a verbal briefing.
Okay, so who is the exempt staffer that you can say reads 100% of the intelligence assessments?
Mr. Chair, again, I've answered these questions, and
I think you said your chief of staff. Is that correct? Does your chief of staff sees every single one?
Yes,
Okay.
very
Right.
specifically, Mr. Jennings. You've asked those questions now on numerous occasions. I think you're attempting to portray that I'm being evasive.
No.
I'm not. I've been very forthright. I said the deputy minister and the chief of staff are principally responsible in the prioritization of intelligence that comes before my eyes. That's very clearly on the record now, numerous times.
And they read
Point
every
of order,
single one.
Mr. Chair. The whole line of questioning
I'm out of
from
time anyways.
from Mr. Jennings has been focused on anything but S8. I haven't heard a single. Maybe there might be one or two in the record, but almost all of them have nothing to do with S8.
And we go to MP Sarai. You have 4 minutes.
Thank you, Minister, for coming. My question is, this piece of legislation, S8,
combined with SEMA, combined with the Majinsky Act, kind of tighten the legislation to make it a criminal offense for contravening or failing to comply with sanctions, which in all three cases I think is a hybrid offense, allowing violators to be charged with either a summary conviction or an inadmissible offense. I want to know, would the minister, the department's stance be to deport such a person if they're in Canada or charge them? We also don't want Canada to be a safe haven where you can go and try there, and if you don't, the worst case, you just go back. If they have contravened any of these acts, would that be, in your purview as a public safety minister, something that they should be charged for, or would be the de facto that they be sent back?
Mr. Chair, it's an important question, and yes, if someone is deemed inadmissible under the Immigration Refugee Protection Act, that we can then, by consequence, commence deportation proceedings to remove them.
But if they've contravened an act and we can charge them here in Canada, would we pursue charges against them here? Because sometimes in that case, that might be a win-win for them to be able to just go back and not be charged when they've actually committed an offense, and in that country will not charge them.
Yeah. I think it's important to point out that certainly as it relates to proceedings for removals, including any other administrative proceedings, that we allow for due process to take its course. I beg your pardon. There are important procedural rights that any individual who faces stark consequences, including removal and or detention, are entitled to. And what this bill will do is ensure that there is due process prior to the invocation of the amendment under S8, and that due process exists on the front end under the analysis that is undertaken by Global Affairs Canada, and then on the back end, if the individual who has been listed under SEMA and is therefore inadmissible under IRPA does always have the option to seek judicial review before the federal court.
The other question I have is more to do with inadvertent overreach. A lot of times we as constituent MPs get cases of people when they're young, part of activist movements. That activist movement, they might have just went to a rally or participated in a town hall or some sort of a little protest, and then eventually they're considered labeled with that, even though they had no violent actions or whatnot. Are there protective measures to make sure there isn't inadvertent overreach for people that were just involved in a rally or whatnot, but never were part of any criminal activity?
Mr. Chair, I believe there are sufficient checks and balances through the due process that the individual is afforded by the analysis that is undertaken by Global Affairs, and certainly thereafter, if there's any question about how that discretion was exercised by officials, and then under IRPA, that they can seek judicial review before a federal court. But I would point out that these individual cases are taken very seriously by Global Affairs, that listing somebody under SEMA is not a trivial thing, that attention is care to examining the facts on the merits. And that is because we recognize what's at stake for those individuals. Being rendered inadmissible is a serious, serious thing. And so, therefore, we have put in place the appropriate checks and balances into the process prior to sanctioning an individual under SEMA and, by extension, rendering them inadmissible once this provision becomes law.
And will groups have the ability?
Mr. Sarai, I'm afraid you're out of time.
Sorry. Thank you, Minister.
So at this point, it being almost 10 after 12, I wanted to thank you, Minister. You were very, very generous with your time. And also, I should say that some of the questions did not appear to be relevant in the least bit to me, but you were incredibly forthcoming in responding to those as well. So thank you for appearing before our committee. Very grateful. We will now suspend very, very briefly for a minute or two, just to allow the Minister to leave and the officials to take over. So welcome back, everyone. We will continue on with a consideration of Bill S8. We're very fortunate that we have a number of officials here with us. If it's okay with everyone, I will dispense with titles, but will say that from Canada Border Services Agency, we have Ms. Kelly Acton. We also have Mr. Brett Bush. From Department of Citizenship and Immigration, we have Ms. Simone Fredette and Mr. David Chan. From the Department of Foreign Affairs, we have Mr. Stephen Burridge. And from the Department of Public Safety and Emergency Preparedness, we have Mr. Sebastian Oberton Giguere. So for this round, we have 6 questions, 5 minutes each. And we start off with MP Epp. You have the floor.
Thank you, Mr. Chair, and thank you to the officials for being here. I was struck as the minister, in his opening comments, referred to this as a bill to make sure that no bad actors, I think was his direct language, would come into Canada. And he also later on commented that the bill aims to be precise. And so I'm wondering if someone could comment as to, is the overall intent of this bill to be I find that language at odds with each other. And so can you comment is the goal to be more precise, more prescriptive, or is it to increase the amount of latitude to administer?
Thank you very much, Mr. Chair. So I think in response, I would turn first to colleagues at GAC. I think it is, it's about alignment. So when you are sanctioned, that means you are then inadmissible to Canada. So we have a regime, and the inadmissibility regime was not aligned with that. It is now. And the precision, I think, is really around how, just how sanctions are applied then and how that relates back to inadmissibility.
Yes, thank you, Mr. Chair. Just to add to that, I would say that certainly Canada is very judicious in its approach to employing sanctions. And when it comes to this particular bill and the amendments that it makes to IRPA, it does bring all of our autonomous sanctions regimes in line when it comes to inadmissibility, thereby any individual or entity that is listed for any of the triggers under CIMA, of which there are 4, including the human rights, violations, corruption, as well as a grave breach of international peace and security.
Thank you. Sorry to cut you off. I just do have a little bit of time. So speaking of alignment then, if that is the goal, can this be characterized as a follow-up then? And my colleague from Mr. Bergeron references an earlier testimony from the 2017 recommendations from this committee, where the CIMA basically this was intended to address and bring CIMA into alignment with IRPA?
Yes, I think we would say that. Brett, is there anything you'd like to add?
Okay, any comment as to why 2017 and this is 2023?
I would just offer that I think it's a complex area, as we have been discussing, and we have undertaken the work necessary, and the bill you have before you is a reflection of the work that has been undertaken since the committee's report.
So is the department then looking at other recommendations from studies from around that era that are still not brought forward? I'm concerned, right, that it's 2017, it's now 2023. The work that we're doing in other studies at this committee, can we expect responses in 2029? I guess that's what I'm trying to get at. My other colleague, whose birthday is today, made the statement that the business of government seems to not be quick. Can you comment?
Thank you very much, Mr. Chair, for the question. I would invite my colleague Brett Bush just to reflect on any other sort of inputs, I think, in the formulation of this work that would be helpful to the committee to understand.
Thank you, Mr. Chair. I think it would be important to note that since 2017, there's been 2 rather large events that colleagues around the table here have been trying to deal with. The first was the influx of refugees that the government just dealt with through the expansion of the Safe Third Country Agreement. And the second was the dealing with border management during a pandemic. The work did not stop on trying to assess the input from this committee and trying to advance these things. There are, however, realities that we're all dealing with to be able to move things forward during all of this same period of time.
Thank you. During the Senate committee hearings, it was identified that about 2,200 sanctioned individuals would have remained inadmissible without this act coming in. Have any of those applied for visas to come into Canada in the interim?
There have been a very my apologies. There have been a very small number of people that have applied for visas and have been refused that are currently covered by sanctions. But the normal course of events would not anticipate that large numbers of sanctioned people would be seeking to come to Canada or traveling as a regular course of business. That being said, it's trying to close the gap to make sure that all of the sanctions that are covered under CIMA and as well as by the United Nations and other international groups that Canada is a member of, to make sure that those sanctions are being applied equitably here so that we're maintaining our support for those things.
So on what grounds were those visas, that small number of visas, refused in the interim?
So the current provisions of 35(1) permit, in IRPA, sorry, my apologies, it's getting very technical. There are certain provisions in the Act that allow for two of the provisions of CIMA to determine people to be inadmissible. And then there are provisions of, as was mentioned earlier, the Magnitsky Act that would allow us to stop people from coming into Canada.
So I'm going to come back to the point I was trying to make earlier. Does S8 expand the scope?
So now we go to Ms. Bendayan. 5 minutes.
Merci, Monsieur le Président. Thank you, Mr. Chair. Thank you for being here. During the Senate debates, there were some amendments made to S8 to avoid any conflicts with the Firearms Act C-21. Can you confirm, of course this is a bill that matters to me a great deal, I worked on it, can you confirm here that following these amendments brought forward in the Senate, there is no longer any conflict between S8 and C-21? Yes. We work diligently to make sure that there is a good consistency to make sure that the framework remains. Thank you. I think it was at second reading of S8 that Minister Mendicino said, and I quote in English,
issued against groups and non-state entities such as Al-Qaeda or ISIL do not automatically trigger sanctions-related inadmissibility grounds, end quote. Does that mean that individuals that are part of Al-Qaeda or ISIL, or should we sanction, for example, the Wagner Group, that individuals that are part of this group are not automatically sanctioned? And if that's the case, can you explain the process by which they would be sanctioned?
So if I may, I would invite GAC just to speak to the sanctions process and then the application of that to the inadmissibility regime. Is that?
Thank you, Mr. Speaker. So individuals and entities that are listed under Canada's autonomous sanctions are subject to a dealings prohibition, which means that Canadians or persons in Canada cannot actually transact with those individuals or entities.
Come to Canada automatically?
If they're listed, then they would be inadmissible by the new provisions under S8, should they be listed under any of the triggers. Previously, they would have been inadmissible had they been listed under the human rights or corruption trigger of either CIMA or the Justice for Victims of Corrupt Foreign Officials Act.
Do other officials have anything to add to that? If not, I have a follow-up.
What my colleague said was correct. Once they are listed under certain provisions of CIMA, they would be inadmissible to Canada. The challenge, the question that you asked was about non-state actors. In this particular question about terrorists, the sanction provisions currently, the way the the Immigration Act as written would not automatically deem them inadmissible by virtue of that sanction at the United Nations or under CIMA, or if they're the provisions of CIMA that are not currently covered by the Immigration Act, they would not be deemed inadmissible to Canada. That being said, there are other provisions in the Immigration Act that cover people being terrorists and being inadmissible to Canada. So there is your question, we'd have to look at the individual circumstances of the individual case to determine if they're inadmissible.
Okay, I'm not sure then if you can answer this question, but in June 2022, at the Senate Foreign Affairs Committee, government officials testified that about 2,200 individuals were currently sanctioned but not inadmissible to Canada. So if S8 were to pass, do you know how many individuals would be inadmissible, based on S8?
Yes, so the numbers will change depending on who is being sanctioned, but currently, based on the sanctions that are currently in place, it would be an additional 2,700 people that would be inadmissible to Canada.
Okay. Thank you. Mr. Chair, how much time do I have remaining?
5 seconds remaining.
Okay, and I guess I would like to build on Mr. Sarai's question in regards to accidental listings, if I have time. But first, can you just clarify if any of Canada's partner countries have implemented similar measures to S8?
So our partner countries have legislation that's very different than Canada's legislation, but we all tend to arrive at similar places where the governments are wanting to announce sanctions against individuals, countries, actors, to be able to bar them from travel to their country.
Okay. And I guess as a final question, just, okay.
We're out of time.
Merci.
So now we go to Mr. Bergeron. You have 5 minutes, sir.
Merci, monsieur.
Thank you, Mr. Chair. I'd like to get back to the previous question from Madame Bendayan regarding those 2,000 individuals. It seems it may be even more people today that are inadmissible, remain inadmissible to Canada. In this committee's study of last June, of course, we made this information public as to the 2,200 and I think 2,700 now individuals who remain inadmissible. The government has said that between 27 and 2022, 25 individuals sanctioned under the United Nations Act, the Special Economic Measures Act, or the Justice for Victims of Corrupt Foreign Officials Act, had been refused visas. So we know that out of these 2,200 individuals, 25 were not able to get a visa. Have any of these individuals been granted visas? Thank you for the question. I would propose to have Mr. Bush clarify those figures there to make sure we have the right number. About 2,900 at this point, and perhaps colleagues from immigration can address your issues as to visas. Yes, I'm sorry. Just for purposes of clarification, the number of individuals that could be affected by this new legislative measure could be 2,900 people who would be inadmissible to Canada.
For the question about visas, I would turn to my colleagues at Immigration.
Thank you, Mr. Chair. I'm sorry, I missed the specific question that you had about visa refusals.
So what I was saying is that during the Senate Committee's debate at the Senate Foreign Affairs International Trade Committee debate on S8 in June 2022, there was mention made of these 2,200 sanctioned individuals who would remain admissible to Canada. At the time, the government officials said that 25 individuals sanctioned under a number of different regimes would have been refused visas. My question, among those individuals, are there individuals who would have received or who have received visas from the government?
Oh, I see. Thank you, Mr. Chair. Thank you for your question. So, yes, my understanding is that upon the passing of this bill, approximately 2,200 people that have been sanctioned since the invasion of the Ukraine would now be captured under this bill. And prior to that, between 2017 and January 2023, the number is about 25 in terms of the number of visas that have been refused for individuals that are inadmissible based on current sanctions. And so we don't have numbers in terms of out of those 2,200, how many of those would be refused. Like at this stage, those individuals wouldn't be refused.
Informations que vous nous donnez sont celles qu'on...
The information you're providing is what we've been saying for a while now, but what we need to know is among these individuals, 2,200 people, how many of those were admitted to Canada since 2017?
Information with me, but I can return with that.
Vous allez nous revenir avec l'information.
You'll get back to us with that information. Thank you. Okay. Still, in the context of that debate, amendments to the bill were raised as to amendments that would be brought to ERPA. Sections 5 and 6 of the bill focus on clauses, focus on a country, an entity, or an individual. The problem is that the concepts of these three concepts are not defined. So some people consider the vagueness of this statement to mean that an individual could be inadmissible or found inadmissible to Canada. I discussed this with the minister, but honestly, I'm not sure I understood his answer clearly. So we could end up in a situation where refugees, for instance, conscientious objectors, people who are opposed to war, and who might end up in jail in Russia, could end up not having access or be inadmissible to Canada. Is this a well-founded concern? Thank you for the question, Mr. Chair. I would invite Mr. Bush to answer that question, just to explain that it's not a sheer accident that some individuals end up on this list, and at least you'd understand the approach in the definition of these terms.
Very briefly, Mr. Bush.
Oh, I'm sorry.
Very briefly, because we're over time, 40 seconds over, so.
Sorry.
Very, very briefly.
I'll be very brief in English, and sorry. First, the bill allows for people who are sanctioned to make refugee claims. I know that keeps coming up. Second, it is very important to remember that we are trying to keep a clear division between the decision-making process for sanctions, which belongs with global affairs, outside the reach of the Minister of Public Safety. It will rest with the Minister of Foreign Affairs. It's very important to make that distinction and not import the language from CIMA into ERPA so that we start getting into all sorts of situations where we're conflating decision-making and appeals. And if I may just make one last statement, Mr. Chair, I think it's very important to understand that country as a term already exists in the legislation. We would be adding in an alignment of the legislation to make sure the terms allow us to cover the people that are designated, as my colleague at Global Affairs has already mentioned.
Ms. McPherson, you have 5 minutes.
Thank you very much, and thank you for providing all of this clarity, and certainly don't apologize for us taking too long as we ask questions of you. But I did want to follow up on that. So you had talked a little bit about that separation. So the sanctions are determined by global affairs, not immigration, but yet if you wanted to appeal it, you then have to go back to global affairs, to the Foreign Affairs Minister to the United Nations. Is that correct?
So the processes of sanctions are in the domain of my colleague from Global Affairs, so I will not speak to that particular process. But
the appeal process.
The appeal process against the sanction will continue to rest with Global Affairs. There are recourse mechanisms to allow for people against the issuance of the removal order and things of that nature that are in the bill and will be permitted 4 people.
Okay.
We have to keep in mind that this particular provision is very different than the current inadmissibility regime in IRPA, because this is a temporary inadmissibility that's linked to the sanction. When the sanction is lifted, at whatever point in time the sanction is lifted, the people cease to be inadmissible to Canada by virtue of that sanction. So it's very different than other inadmissibilities found in IRPA.
So of course, I mean, the fact that I can't understand it is probably a thought on me more than anything else. But I do wonder, should there be a review process as part of this bill? Is there a plan for a review process with this bill so that if these complexities result in unintended consequences, is there a way for us to make sure that this bill is doing what? Like, is there a process in place for that?
Thank you very much. So I think maybe just to reiterate, like the 2 processes that are baked in. So if an individual finds themselves on the sanctions list, the recourse is through the mechanism for the determination of sanctions. So that exists, that is in place. And then with respect to the inadmissibility decision, as Mr. Bush has explained, there is legal recourse, and that is consistent. And we have tried to make sure that as we have brought in this provision, recognizing the difference between, in the temporary nature of it, but to align it with how we have constructed the inadmissibility regime more generally.
So is there a review mechanism planned for this legislation then, to make sure that it is working?
So I think what we would say is the recourse is already in place as we have laid it out, and that is part and parcel of the.
No, I don't mean for individual people who are applying. I mean the legislation to see if it is working, like a legislative review. Like often legislation has like a let's check in 5 years in and see if it's working kind of thing.
So let me, happy to come back to you on that.
Okay. So one of my thoughts on this a little bit is that we, I worked with global affairs in my previous life quite a bit, and I am concerned when I hear things that say that there are multiple processes, that multiple departments, multiple ministers, multiple processes, because, of course, this is a very complex issue. This is very costly. I think we can all agree that would be one of the things that would happen. And then also, of course, people are at their most vulnerable at the time that they may need to access these costly, complex, and difficult processes that involve multiple ministers and multiple departments. So I am a little bit concerned that is the case. Now, I agree with people in this room that we want to do everything we can to ensure people aren't on those lists, but I am a little bit concerned about that. I have a couple questions, perhaps for our GAC officials. How many individuals have applied to the Minister of Foreign Affairs to be delisted or to file a claim of mistaken identity?
Thank you, Mr. Chair. I'd have to come back to you on the number of individuals who've applied for delistings.
Okay.
But I do think it's important just to clarify that when we're talking about inadmissibility, we really are talking about those individuals and entities that have specifically been listed. So
but perhaps erroneously. It happens.
Right. But I guess the point being that the country, sanctions against a country, which can include things like an import ban or an export ban, don't, by virtue of having those sanctions on the country, mean that any individual from that country is inadmissible to Canada. It really is based on the listing of the individual or the entity specifically under our autonomous sanctions regime or through the UN.
But like we've got examples where people have been put on no-fly lists, for example, because of mistaken identity, because they shared. Like, is there that risk? Like, do we have that risk of that happening?
I think that, as I mentioned before, Canada is very judicious in our approach to applying sanctions. We do undertake very careful due diligence to look at not just the impacts on the individuals or entities that we're listing, but also impacts on Canadians or Canadian businesses as well.
But this would be an appeal because maybe the judiciousness hadn't worked. But I think I'm out of time, aren't I? Yeah.
So we now go to Mr. Genis. You have 5 minutes. Mr. Rep. Oh.
Thank you, Mr. Chair. And I just want to follow up where I left off earlier around the concept of ministerial discretion. So S8 is the framework that links together IRPA, Citizenship Act, Emergencies Act, closes loopholes, links sanctions and admissibility, and then it adds ministerial discretion. So we're trying to be precise and get that all in. What's the purpose of adding ministerial discretion? What would be an example where something like that would be in the national interest?
So I think so. I'll invite Mr. Bush just to again unpack that a bit, just to get to the heart of your question.
So I think Mr. Epp is referring back to the comments from the minister earlier this morning, and I would say that what I think we need to be clear about a couple of things. First, the Immigration and Refugee Protection Act already links certain provisions of CIMA into admissibility. What this bill is proposing to do is to link the last two remaining pieces from CIMA into an admissibility regime, so that the government can have confidence that when they are sanctioning a group of people by name, that they would also be inadmissible for traveling to Canada. The discretion comes with the listing process. It also will make it clearer and more straightforward for our officers to be able to deal with the admissibility concerns of an individual who is listed, because it will be clear that once they are listed in CIMA, period, they will be inadmissible to Canada. I would...
Thank you. I'm going
Sorry.
to turn the rest of my time over to my colleague, Mr. Hoback.
Thank you, Chair. Yeah, I guess I'm kind of curious, if when this legislation comes into force, is there individuals in Canada that would have to be removed immediately?
Not that I'm aware of.
Not that you're aware of. Are there individuals that have visas that are not in Canada that would have visas revoked?
Not that we're aware of at this time.
Is it possible to have an individual sanctioned, but the country itself not necessarily on a concern list?
So, GAC, just again on the sort of application of sanctions, if you could.
So again, as I'd mentioned earlier, individuals and entities are specifically listed under our autonomous sanctions regime, as well as under UN sanctions. When individuals are listed, they are specifically named as well. I would say from a practical perspective, individuals coming to Canada because of the dealings ban, it would be very difficult for Canadians to actually interact with them because they would be violating sanctions. So to the point of my colleagues...
Let me use an example, a drug lord out of South America. The country may not be a problem, but that drug lord could be a problem. So could you see that person being sanctioned in this scenario?
I don't want to hypothesize on potential sanctions and get ahead of any decisions of the Minister of Foreign Affairs, but certainly we look at every case very carefully. Like I said, it's a
Minister of Foreign
judicious
Affairs
approach.
would make the decision then in this scenario. Is that what you're saying?
I'm sorry, could you repeat the question,
So you're
please?
saying the Minister of Foreign Affairs would make a decision in this type of scenario?
Ultimately, sanctions recommendations are put forward to the Minister of Foreign Affairs, who would decide on presenting a recommendation to the Governor and Council, who ultimately would sign off on a sanctions listings.
Okay, so you would do the grunt work, for lack of a better word, and then the Minister would look at the information and decide accordingly. In regards to property that's being held in Canada by somebody that goes onto the sanction list, will you be actually making actions against that property? Would you be seizing it? What happens in those scenarios?
So in June of last year, the government passed new amendments to both the Special Economic Measures Act and the Justice for Victims of Corrupt Foreign Officials Act, which gives the government the authorities to seize and forfeit any assets that are held in Canada. by a listed individual or entity. That decision is looked at on a case-by-case basis, and assets in Canada, especially financial assets, are proactively disclosed by financial institutions to the RCMP.
Okay, so
out of time, I'm afraid. We now go for the last question to Mr. Oliphant. You have 5 minutes.
Thank you, Mr. Chair. A couple of quick questions to make sure we're all on the same page. First thing is, my colleague, Madame Bendayan, brought forward the issue of the problem of Bill C-21 and a concordance issue to make sure we weren't superimposing an act over something that's just been changed. Do you know of any other acts that we may need to make amendments for in this act to make sure that we are not tripping over ourselves as well?
I think just I would offer that, Mr. Chair, in terms of coordinating amendments, there were changes made to the inadmissibility regime under the S-223 around trafficking in human organs, and so just in bringing these additional changes to the inadmissibility regime, there are coordinating amendments.
So my understanding that there would be a need to be technical amendments to coordinate S-223, which was Senator Tulijan's bill, sponsored by Mr. Jennis, to make sure we don't superimpose something over a bill that we just passed.
Correct.
So we may have some amendments that the government would need to bring on that issue. That's not my department, but I understand that may happen. Okay, I wanted to clarify that. The second issue, I feel a little bit like I'm in an alternative universe. And it seems to me that we have blended a bunch of issues, and I just want to make sure if I'm explaining this to my constituents, I'm correct. We have a sanctions regime that is operated very different from criminal checks under our immigration or public safety thing. We have a sanctions regime that has 3 possible acts: CIMA, the Magnitsky Act, and our UN agreement. That is a process that you do. We have people that may have been falling through the cracks, allowed to come in because there's been discretion in the system where visa officers may not be following this stuff. And we're making it very clear under IRPA that if you're sanctioned under these sections, you are inadmissible as opposed to discretionarily inadmissible. Am I correct on that?
Yes,
and the process of sanctioning is a temporary measure taken, hopefully, inshallah, to make sure that people change their behaviors, and you can get off that list if you change your behavior. Like, that's the nature of a sanction. Am I correct?
Thank you, Mr. Chair. I would say sanctions ultimately have a number of goals, one being to change the behavior of states or individuals, but also there are other impacts that sanctions can have, including signaling, preventative, et cetera.
Yes, so we're saying a strong message. What we're adding by this kind of housekeeping bill is to make sure that our 3 regimes that we do sanctioning on are in agreement with the Immigration Refugee Protection Act, admissibility, and then would be implemented through removal orders if they're in Canada by public safety. CBSA would be monitoring this, so that we have double checks. So this is, to me, not a big deal. And am I missing something? Because we do have procedures where you can be taken off a sanctions list. There is an appeal process under those. The UN one is a little bit different, but under that, we'll get into that under sanctions. But there is still some degree of discretion if there have been mistakes made, but largely this bill is to take the discretion out of that to ensure the bad people don't get to squeak through and get into Canada when they've been sanctioned. Trusting our sanctions regime, which is very rigorous, is correct. Am I getting it so I can explain it to the people of Don Valley West?
Thank you. Yes, I think this is a closing of the gap. It is an alignment of regimes. I think also fair to say it doesn't actually introduce necessarily new discretion, but as you say, it is about alignment across
Last question, probably running out of time, is other countries have sanction regimes. And we try to do our sanctions in concert with other countries because they're more effective if we do it with the EU, with the UK, with the US, with like-minded partners, etc. Do other countries have a similar thing about inadmissibility with sanctions? Are we getting in step with them? Are we leading the pack? Are we behind the pack? Where are we with other countries on the relationship between admissibility and sanctions?
If you
knowing
could
we have
answer
a very
in
different immigration and
approximately
refugee
20
protection
seconds,
act.
please.
Thank you, Mr. Chair. Very quickly, yes, this would be bringing us in alignment with the measures that a number of our allies are able to impose, including our G7 partners. Some of them are linked to sanctions directly. Others, including the United States, have other mechanisms that allow them to impose things like visa or travel bans. But this will give us that ability to ensure that all of those listed under our sanctions are inadmissible.
Thank you. Nope,
Mr.
I'm
Rapp.
afraid not, Mr. Alfred. You have no time remaining. So at this point, that concludes the questions. Allow me to thank all of the officials who appeared before us today. Thank you, Mr. Bush. Thank you, Ms. Acton. Thank you, Mr. Aubertine Giguère, Ms. Fredette, Mr. Chan, and Mr. Burridge. Very, very grateful for your time and for your patience in explaining this framework to us. Now, we will give the officials a few minutes to leave, but we will very soon be going into in camera to talk about the travel proposal. 1 minute? Okay. We're really short. Yes.